Before we begin, a quick and important disclaimer. The following content is for educational and entertainment purposes only and does not constitute professional legal advice. The legal landscape regarding family law has shifted dramatically since the mid-20th century, and the historical trends discussed here are intended to provide context on the evolution of the American justice system, not as a guide for contemporary legal matters. Viewers should conduct their own due diligence and consult with a licensed attorney in their jurisdiction for any specific legal concerns or proceedings. In 1952, if you walked into a wood-paneled law office in downtown Chicago or New York City seeking a divorce, you weren't just entering a legal consultation. You were entering a theater of war where the scripts were written by the state, and the actors were often forced to commit perjury just to reclaim their freedom. Imagine a world where being unhappy wasn't a legal reason to end a marriage. Imagine a world where, to get a divorce, you had to prove your spouse committed a moral atrocity, or better yet, hire a private investigator to snap a grainy photograph of them in a hotel room with a hired stranger. This was the era of fault-based divorce, a time when the divorce lawyer was part investigator, part moral arbiter, and part shadow operator in a system designed to keep people together at almost any cost. By the end of this deep dive, you will understand how the legal gatekeepers of the 1950s navigated a labyrinth of collusion, strict social morality, and migratory divorce hubs like Reno, Nevada, creating a multi-million-dollar industry built on the back of institutionalized secrets. Understanding this history is not just a dusty academic exercise, it solves a fundamental mystery for the modern American audience: why our current legal system is so obsessed with documentation, and why the no-fault revolution of the 1970s was considered one of the most radical shifts in U.S. civil law. By peeling back the layers of the 1950s legal machine, we can see the origins of modern privacy rights, the financial evolution of alimony, and the historical precedent for how the law reacts when social reality clashes with rigid legislation. To understand the 1950s divorce lawyer, you first have to understand the sheer weight of the fault system. In nearly every state, the law operated on a simple, brutal premise: marriage was a permanent contract that could only be breached if one party was guilty and the other was innocent. There was no such thing as a mutual agreement to disagree. You couldn't just fall out of love. To get a judge to sign a decree, the plaintiff had to prove one of a handful of specific grounds. These typically included adultery, physical cruelty, desertion, or incurable insanity. If you couldn't prove one of those, you were legally bound to your spouse for life, regardless of your personal misery. This created a massive professional dilemma for the 1950s attorney. If a couple both wanted a divorce, they were technically barred from getting one. Under a legal doctrine known as collusion, if a husband and wife agreed to divorce, the court would view it as a fraud against the state and dismiss the case. The law required an adversarial conflict. This led to the rise of what historians call the divorce mills and the staged adultery industry. A lawyer in 1955 often had a Rolodex that included more than just junior partners. It included professional correspondents, individuals, often young women, who were paid to be photographed in compromising, yet ultimately innocent, positions with a husband so the wife could sue for divorce on the grounds of adultery. The logistics of these staged events were meticulous. The lawyer would coordinate the time and place, usually a hotel. The adulterous spouse and the hired correspondent would enter the room. A private investigator, also tipped off by the lawyer, would then burst in and take a flash photograph of the couple. Usually, the parties were fully clothed, perhaps just removing a jacket to suggest intimacy. These photographs were then presented in court as irrefutable evidence. The judges often knew these setups were fraudulent, the lawyers knew they were fraudulent, and the clients certainly knew. Yet, the entire legal apparatus participated in this charade because it was the only way to bypass the restrictive statutes of the era. Beyond the staged theatrics, the 1950s divorce lawyer had to be an expert in the migratory divorce. For those with the financial means, the strict laws of states like New York, where adultery was the only ground for divorce until 1966, were a barrier to be bypassed. This gave rise to the Reno divorce. Nevada had a residency requirement of only 6 weeks and recognized extreme cruelty, which could be interpreted as mere mental distress, as a valid ground. A lawyer's job in this context was as much travel agent and residency strategist as it was legal counsel. They would coordinate their clients' stay at divorce ranches, where wealthy socialites would wait out their 6 weeks in the desert, shedding their wedding rings into the Truckee River the moment the decree was signed. For the average American lawyer who wasn't sending clients to Nevada, the daily reality involved cruelty cases. Because adultery was scandalous and difficult to prove without professional help, extreme cruelty became the catch-all. However, the evidentiary standards were high. A lawyer had to coach their client to testify about specific instances of domestic upheaval that met the statutory definition. This often involved a corroborating witness, usually a neighbor or a relative, who would take the stand to swear they saw the defendant shouting or acting in a way that caused the plaintiff great mental anguish. This forced legal professionals into a position where they were essentially scripting domestic tragedies for public consumption. The financial stakes were handled with a similar level of rigidity. In the 1950s, the concept of equitable distribution of assets didn't exist in most states. Property generally belonged to whoever held the title, which in the mid-century gender economy was almost always the husband. Alimony, or separate maintenance, was not a temporary bridge to self-sufficiency as it is often viewed today. It was a permanent pension for the innocent wife, paid by the guilty husband. However, if the wife was found to be the guilty party, especially if she committed adultery, she could be stripped of any right to financial support, leaving her destitute. This made the lawyer's role in proving fault a high-stakes financial battle. A single piece of evidence could mean the difference between a life of middle-class comfort and total poverty for a woman of that era. We also see the 1950s as the era where the best interests of the child standard began to take a more modern shape, though it was still heavily weighed by the tender years doctrine. This doctrine presumed that young children should naturally be with their mothers. A father's lawyer in 1958 faced an uphill battle that is almost unimaginable today. Unless he could prove the mother was unfit, usually through evidence of immorality or alcoholism, custody was a foregone conclusion. The lawyer's strategy was often to weaponize social stigmas, using a mother's desire for a career or her social life as evidence of her unfitness to parent. This decade represented the absolute breaking point of the fault-based system. The tension between the rigid moral laws on the books and the actual lived experiences of millions of Americans was reaching a fever pitch. Lawyers were increasingly frustrated by a system that forced them to be complicit in perjury. The deep dive into this era reveals that the 1950s weren't just a time of white picket fences and stable nuclear families. They were a time of intense legal repression that birthed a clandestine industry of private eyes, secret hotel meetings, and Reno-bound trains. As we move into the subsequent parts of this series, we will examine the specific case files and the legislative battles that eventually led to the collapse of this system. But first, we must understand the sheer complexity of the legal fiction that every divorce lawyer in 1950s America had to maintain just to do their job. To truly grasp the cognitive dissonance required of a 1950s legal professional, imagine if in 2026, the only way to cancel a streaming subscription was to prove in a court of law that the CEO of the company personally insulted your mother. It sounds absurd, but for a divorce lawyer in 1954, absurdity was the daily bread. We are moving now into the tactical reality of the fault-based system, specifically the high-stakes game of proving adultery and the professionalization of the private investigator. This was an era where the lawyer acted as a director of a film that no one wanted to star in but everyone had to watch. Consider the case study of a fictional but representative 1950s professional named Arthur, a high-earning architect in suburban Connecticut. Arthur and his wife, Eleanor, have reached a point of silent resentment. There is no abuse, no gambling, and no third party. They are simply two people who have grown apart in a decade defined by rigid social expectations. Arthur approaches a lawyer in Manhattan. The lawyer doesn't ask about Arthur's feelings or his hopes for the future. Instead, the lawyer looks across the desk and asks a single cold question. Who is going to be the guilty party? In New York in the mid-50s, the legal trend was so restrictive that adultery was essentially the only path to a decree. If neither Arthur nor Eleanor had actually committed adultery, the lawyer had to navigate a historical trend known as the staged raid. This was a step-by-step operation. Step 1 involved the lawyer contacting a specialized agency. These agencies didn't just investigate, they provided the cast. They would hire a woman to meet Arthur at a midtown hotel. Arthur would check in under a false name, accompanied by this stranger. Step 2 was the timing. The lawyer would coordinate with a private investigator and a photographer. At a precise moment, usually around 2 a.m., the investigator would use a passkey or a forceful shoulder to enter the room. The photographer would set off a blinding magnesium flash, capturing Arthur in his shirt sleeves and the hired woman in a slip, sitting on the edge of the bed. Step 3 was the testimony. In court, the investigator would testify under oath that he observed the couple in a state of undress, providing the circumstantial evidence required to meet the legal burden of proof. The lawyer would present the photograph as Exhibit A. Everyone in the room, the judge, the court reporter, the opposing counsel, knew the woman was a professional witness paid $50 for her evening's work. Yet, as long as the testimony was delivered without a stutter, the law was satisfied. This was the legal fiction in its most distilled form. But what happened when the stakes were real? What if the adultery wasn't staged? This is where the 1950s lawyer became a master of surveillance and psychological warfare. In an era before GPS trackers or digital footprints, a lawyer's primary tool was the stakeout. Historical trends show that a significant portion of a divorce lawyer's overhead was paid out to investigators who spent weeks sitting in parked cars, documenting the exact minutes a spouse entered and exited a residence. Let's look at the financial architecture of these cases. Because the innocent party was often awarded a larger share of the marital assets and permanent alimony, the discovery of a single love letter or a receipt for a jewelry purchase could swing the potential outcomes of a settlement by tens of thousands of dollars. A fortune in 1950s currency. Lawyers would instruct their clients to mirror the tactics of intelligence officers. They were told to check the mileage on the car every night, to steam open mail, and to listen in on party line telephone calls. The lawyer then had to take this raw, often sorted data and sanitize it for a conservative judiciary. They had to frame the client as the moral victim of a decadent spouse, regardless of the reality behind closed doors. Then there was the issue of the migratory divorce and the legal loophole of the 6-week residency. Imagine a 2026 traveler going to a specific state just to bypass a federal tax. That was the Reno phenomenon. A specialized divorce lawyer in the 1950s had to be an expert in jurisdictional arbitrage. If a client was wealthy enough, the lawyer would arrange for a 6-week leave of absence. The lawyer would coordinate with a Nevada-based firm to ensure the client met the residency requirements. This involved more than just staying in a hotel. The client had to show intent to remain, which meant the lawyer would advise them to open a local bank account, get a Nevada library card, and even register to vote in Washoe County. The strategy was to create a paper trail of residency that could withstand a challenge back in the client's home state. This was crucial because if the stay-at-home spouse didn't recognize the Nevada divorce, they could sue in their home state for bigamy if the other spouse remarried. The lawyer's job was to secure a notice of appearance from the other spouse. They would often use the alimony payments as a carrot. The lawyer would tell the opposing party, "If you sign this document acknowledging the Nevada court's jurisdiction, we will increase the monthly support by 20%. If you don't, we will tie this up in the local courts for 5 years and you won't see a dime." It was brutal, transactional, and required a lawyer to have the nerves of a high-stakes gambler. We must also examine the professional risks these lawyers took. While the system was complicit in the staged adultery raids, the threat of disbarment for suborning perjury was a constant shadow. A lawyer had to be incredibly careful with how they coached their clients. They couldn't tell a client to lie, but they could say, "The court needs to hear that your spouse's behavior caused you such distress that you required medical attention. Did you perhaps see a doctor for a headache last month?" If the client said yes, that headache became a foundational piece of evidence for the extreme cruelty claim. This linguistic gymnastics was the hallmark of a successful mid-century practitioner. In the South and the Midwest, where religious influence was even more pronounced in the legislature, the lawyer's role was even more restricted. In some jurisdictions, even a successful proof of fault didn't mean the divorce was granted immediately. There were interlocutory decrees, a waiting period, where the couple was legally separated but not allowed to remarry for a year or more. The lawyer's job during this cooling-off period was to act as a chaperone, warning their clients that any immoral behavior during this year could result in the judge vacating the divorce decree entirely. This brings us to the dark side of the 1950s legal practice, the weaponization of the unfit mother label. In an era where a woman's social standing was tied entirely to her role as a housewife, a divorce lawyer representing a husband would often scour the wife's life for any deviation from the 1950s ideal. Did she attend too many cocktail parties? Did she have a career ambition that took her away from the home? These were not just social critiques. They were legal weapons used to secure custody of children and eliminate alimony obligations. The lawyer had to be prepared to character assassinate a parent in open court, a process that left deep scars on the families involved and created a legacy of litigation that we are still untangling today. But as the decade progressed, a new type of pressure began to build. The sheer volume of these cases, and the obvious fraud occurring in courtrooms every day, began to alienate the younger generation of legal minds. They began to ask, why is the law forcing us to be liars? Why are we treating a failed contract like a criminal trial? This internal pressure within the American Bar Association started a quiet conversation that would eventually blow the doors off the entire system. In the next part, we are going to look at the secret files of the 1950s investigators, the actual techniques used to catch a spouse in the act. We will explore the specialized technology of the era, from early hidden microphones to the chemistry of developing film in secret darkrooms. We will also dive into the black market of divorce, where those who couldn't afford a lawyer or a trip to Reno had to find much more dangerous ways to disappear from their marriages. The facade of the 1950s was cracking, and the lawyers were the ones holding the hammers. To understand the sheer grit of the 1950s divorce lawyer, you have to look past the mahogany desks and into the grease-stained notebooks of the men they hired to do the dirty work. In 1957, a divorce attorney was only as good as his lead investigator. This was an era where the legal burden of proof for adultery or cruelty required more than just a hunch. It required a physical manifest of betrayal. We are now entering the world of mid-century surveillance, a landscape of graining black and white film, long-range microphones that looked like oversized dinner plates, and the meticulous art of the trash pull. Imagine if in 2026, every text message you sent was encrypted by a third party, but your physical garbage was considered a public goldmine for legal discovery. For a lawyer in the 50s, the garbage can was the primary source of truth. Case studies from this period show that investigators would spend hours in alleyways, looking for discarded telegrams, receipts for floral arrangements delivered to unknown addresses, or even dry cleaning stubs that didn't match the husband's usual wardrobe. These weren't just clues, they were the building blocks of a legal ambush. The lawyer would take these fragments and construct a timeline so precise that the defendant would be forced into a settlement just to avoid the public humiliation of the evidence being read in open court. The technology of the time was primitive by modern standards but utilized with surgical precision. Lawyers often employed investigators who were former military intelligence or ex-police officers who understood the mechanics of the stakeout. Step 1 of a professional surveillance operation involved the two-car tale. In an age of heavy, recognizable steel cars like the 1955 Chevy Bel Air, following someone without being spotted was an art form. One car would follow for 3 blocks, then peel off at an intersection while the second car took over. The lawyer would receive daily logs detailing every stop, from the grocery store to the suspicious 3-hour lunch at a roadside tavern. One of the most effective, albeit controversial, tools in the lawyer's arsenal was the wiretap. While the legalities of domestic wiretapping were in a state of flux during the 50s, many attorneys operated in a gray area. They would hire technicians to physically splice into the telephone lines in the basement of an apartment building, or at the junction box on a suburban street. These recordings were captured on bulky reel-to-reel tape, machines hidden in the trunks of cars. The goal was to catch a confession or a rendezvous arrangement. If the recording itself was inadmissible in court due to local privacy laws, the lawyer would still use it as leverage. They would play a snippet of the tape for the opposing counsel during a pre-trial conference. The message was clear: we have the truth on tape. Do you really want your client to take the stand and commit perjury? This leads us to the concept of the legal squeeze. The lawyer's objective wasn't always to get to trial. It was to create such an overwhelming mountain of documented fault that the other side would capitulate on financial terms. In 1958, a case study involving a prominent textile merchant in North Carolina demonstrated this perfectly. The husband's lawyer had documented a series of secret meetings between the wife and a local musician. Instead of filing for divorce immediately, the lawyer waited until the husband's business was about to go public. He then presented the evidence to the wife's attorney, offering a minimal settlement in exchange for a quiet, uncontested divorce on the grounds of mental cruelty, rather than adultery. The wife, fearing the social ruin that an adultery charge would bring to her family, signed the papers within 48 hours. This was the lawyer as a shadow negotiator, using the threat of social death as a primary tool. But what about the clients who couldn't afford the $500 retainer for a top-tier investigator? This is where the 1950s divorce market split into 2 distinct worlds. For the working class, the lawyer's role was often about navigating the poor man's divorce, which in many cases was simply desertion. Historical trends show that thousands of men in the 1950s simply vanished, moving 2 states over and changing their names to escape a marriage they could not legally or financially afford to end. A lawyer representing a left-behind wife had the unenviable task of filing for divorce against a ghost. They had to place notice of action advertisements in local newspapers for weeks on end to satisfy the court that a diligent search had been conducted. Only then could a divorce by default be granted. These cases were tragic and highlighted the class divide in American family law. If you were rich, you hired a spy. If you were poor, you became a fugitive. Step by step, the lawyer also had to manage the witness preparation for the inevitable court appearance. In the 50s, the corroborating witness was a statutory requirement in many states. You couldn't just have the husband and wife testify. You needed a third party to verify the claims of fault. This often meant the lawyer had to interview the couple's friends, neighbors, or even their children's nannies. Imagine the ethical tightrope. Asking a neighbor to testify that they heard shouting and the breaking of glass on a specific Tuesday night. If the neighbor was hesitant, the lawyer would remind them that they were helping a friend escape a miserable situation. This fostered a culture of social perjury, where entire communities would quietly agree to corroborate exaggerated stories of domestic strife just to help a neighbor navigate the rigid legal system. The financial discovery process was equally grueling. In 1959, without digital banking or centralized credit reporting, a lawyer had to be a forensic accountant. They would subpoena bank ledgers, search for hidden safety deposit boxes, and examine tax returns for unexplained deductions that might suggest a spouse was funneling money into a separate account in preparation for a split. This was the era of the cash stash. Many husbands would begin siphoning off a portion of their salary years before filing, hiding it in accounts under their mother's name or in out-of-state banks. The wife's lawyer had to be relentless, tracing every check and questioning every business expense. The potential outcomes of a divorce often hinged on the lawyer's ability to find that one hidden account. We must also consider the role of the proctor, or the friend of the court. In some jurisdictions, the state actually appointed a third lawyer whose entire job was to represent the interests of the marriage itself. Their goal was to prevent collusion and ensure that no divorce was granted too easily. A 1950s divorce lawyer had to not only beat the opposing counsel, but also convince the state's proctor that the case was legitimate and the fault was real. This created a three-way legal battle where the lawyer was constantly being watched for signs of cooperation with the other side. As we look deeper into the 1950s, we see that the divorce lawyer was the primary architect of the American domestic facade. They were the ones who knew where the bodies were buried, which staged photos were fake, and which happy couples were actually living in a state of legal Cold War. But the pressure was mounting. The 1960s were around the corner, and the social revolution was about to turn the divorce lawyer's world upside down. In the next part, we are going to look at the Reno ranches in vivid detail. We will explore the day-to-day lives of the women who spent 6 weeks in the Nevada desert, the specific legal contracts they signed, and how the 6-week cure became the most profitable niche in legal history. We will also look at the Mexican quickie divorce, a high-risk, low-cost alternative that led to some of the most famous legal scandals of the 20th century. The lines between legal and illegal were blurring, and the lawyers were the ones drawing the map. The map of the 1950s divorce industry had one glowing neon capital: Reno, Nevada. To a divorce lawyer in a high-fault state like New York or South Carolina, Nevada wasn't just a state, it was a jurisdictional release valve. Imagine if in 2026, you could fly to a specific territory where the laws of physics didn't apply just to solve a contract dispute. In the mid-50s, that was the power of the Nevada residency. This part of our deep dive examines the 6-week cure, a legal phenomenon that turned a sleepy desert town into a global hub for domestic litigation and created a specialized class of attorney, the Reno divorce specialist. The logistics of the Reno divorce were a masterclass in legal engineering. Step 1 for the attorney was the residency consultation. A client, let's call her Margaret from suburban Philadelphia, would be told that under Pennsylvania law, she has 0 grounds for divorce because her husband hasn't committed a crime or abandoned her. The lawyer's solution? The migratory strategy. Margaret is instructed to pack a trunk, take a leave of absence from her social circles, and board a train for Nevada. The moment she steps off the platform, the clock starts. Nevada law required exactly 42 days of physical presence to establish bona fide residency. But merely being there wasn't enough. The lawyer had to ensure that Margaret's residency couldn't be challenged later as a sham. This required a step-by-step assembly of a paper life. The Reno lawyer would meet Margaret on day 1 and hand her a checklist. She had to open a bank account at the First National Bank of Nevada, She had to rent a room, typically at one of the famous divorce ranches, like the Flying Me or the Pyramid Lake Guest Ranch. Most importantly, she had to get a Nevada driver's license. The lawyer was essentially helping the client perform a new identity for the benefit of the court. This was the 6-week cure in action, and for the lawyers involved, it was a high-volume, high-margin business model. The divorce ranch itself was a fascinating legal ecosystem. These were not just hotels, they were holding pens for the legal process. A lawyer would often have an exclusive relationship with the ranch owner. The ranch staff were trained to serve as the corroborating witnesses. Remember, the law still required a third party to swear under oath that the plaintiff had indeed been in the state every single day for 6 weeks. The ranch foreman or the housekeepers would regularly appear in court, testifying with a practiced, bored tone that they had seen the client at breakfast every morning for 42 days. This professionalized witnessing was the engine that kept the Reno mills grinding. However, the 1950s lawyer faced a massive hurdle known as the divisible divorce doctrine. This was a historical trend established by the Supreme Court cases of Williams versus North Carolina. It meant that while Nevada could end your marriage, it couldn't necessarily settle your property or alimony issues if the other spouse stayed back home and refused to participate. This created a high-stakes chess match. Margaret's lawyer in Reno would have to coordinate with her lawyer in Philadelphia to trick or pressure the husband into entering an appearance. If the husband's lawyer filed even a single piece of paper in the Nevada court, he was snapped, meaning he had submitted to Nevada's jurisdiction. The Reno lawyer would use every tactic in the book, promising higher child support or threatening a scandalous public trial back home, just to get that signature. If Reno was the luxury option, the Mexican quickie was the high-risk gamble. In places like Ciudad Juarez, a divorce could be obtained in 24 hours, sometimes even by mail. For a 1950s lawyer, recommending a Mexican divorce was a move fraught with professional danger. Case studies from the era show that while these divorces were cheap and fast, their legal validity was a minefield. A lawyer who handled a Mexican divorce for a client might find themselves defending that same client 5 years later on bigamy charges when a local judge ruled the foreign decree void as against public policy. The Mexican divorce was the black market of the legal world, often utilized by celebrities or those in extreme financial distress, but it required a lawyer who was comfortable operating in a legal no-man's land. Step by step, the lawyer also had to manage the return to reality. Once Margaret secured her decree in Reno, she didn't just go home, she had to be reintegrated. The lawyer would advise her to wait a specific amount of time before remarrying to avoid the appearance of predetermined intent. If she remarried too quickly, a disgruntled ex-husband could argue in court that the entire Nevada trip was a fraud from the beginning, potentially nullifying her new marriage and her financial settlement. The 1950s lawyer was constantly managing the optics of their client's life, ensuring that every move looked like a spontaneous reaction to extreme cruelty, rather than a calculated legal maneuver. The financial impact of this migratory industry was staggering. Data from the 1950s suggests that divorce was Nevada's second-largest industry, behind only gambling. Lawyers in Reno were often the highest-paid professionals in the state, charging premium convenience fees, on top of their standard retainers. They weren't just practicing law, they were managing a sophisticated tourism bureau. They would recommend the best ranches, the best shops, and even the best places to buy a divorce ring, a piece of jewelry worn on the right hand to signify one's new status. But this system was inherently elitist. It created a two-tiered justice system in America. If you had the money for a 6-week vacation and a specialized attorney, you could have a clean, relatively painless break. If you were a factory worker in Ohio, you were stuck in the fault trap. This disparity began to catch the attention of legal reformers and sociologists. They argued that the law was effectively for sale, and that the legal fiction of the Reno divorce was making a mockery of the American judicial system. The 1950s divorce lawyer in Reno was a pioneer of what we now call forum shopping. They proved that if the law in one place is too rigid, people will simply find a way to go where the law is more flexible. This realization was the first crack in the wall of the traditional, fault-based marriage contract. It showed that the state could not force people to stay married if they were determined to leave. It could only make it more expensive and more complicated. As we moved toward the 1960s, the Reno loophole started to lose its luster. State courts back east began to push back, refusing to recognize these foreign decrees and leaving thousands of people in a state of legal limbo, married in New York but divorced in Nevada. This chaos led to a constitutional crisis in family law. In the next part, we will dive into the trial-of-the-century-style domestic cases that captivated the 1950s public. We will look at how lawyers used the psychiatric defense, a new and controversial tool where one spouse would try to have the other declared insane just to secure a divorce. We will examine the chilling step-by-step process of the institutionalization strategy and how the lawyer became the gatekeeper of a client's very sanity. The stakes were no longer just about money or freedom. They were about survival in a system that was rapidly losing its moral compass. The weaponization of psychiatry in 1950s divorce court was perhaps the most chilling chapter in the history of the American legal profession. To understand why a lawyer would reach for a medical diagnosis as a litigation tool, you have to look at the hierarchy of fault. Adultery was scandalous and cruelty was common, but incurable insanity was a nuclear option. If a lawyer could prove their client's spouse was legally insane, it didn't just provide grounds for divorce. It often stripped the guilty party of their parental rights, their financial standing, and their very autonomy. Imagine if in 2026, an HR dispute over a remote work policy could end with one party being forcibly committed to a state facility just to settle a contract. In 1955, that was the potential outcome for a spouse trapped in a high-stakes legal battle. The step-by-step execution of the psychiatric strategy began with the selection of a friendly expert witness. In the mid-50s, the field of psychiatry was exploding in the American consciousness, but the legal definitions of sanity remained rooted in the 19th century. A divorce lawyer would maintain a list of psychiatrists who were willing to provide courtroom-ready evaluations. Step 1 involved the client. Let's use the character named David, a successful advertising executive in Chicago, reporting erratic behavior to his attorney. David's wife, Sarah, might simply be unhappy or vocal about her dissatisfaction with the marriage. However, under the lawyer's guidance, this was reframed as hysteria or chronic nervous instability. Step 2 was the forced observation. The lawyer would advise David to lure Sarah into a situation where a hired psychiatrist could observe her under stress. This might happen during a staged domestic argument where the doctor was visiting as a friend of the family. The goal was to provoke a reaction that could be documented as evidence of an unstable temperament. Step 3 was the filing. The lawyer would present a petition for divorce based on incurable insanity, backed by the doctor's testimony. Because the 1950s legal system was heavily biased toward the breadwinner, a husband's word, backed by a professional in a white coat, carried almost insurmountable weight. This led to a historical trend where women were often institutionalized for the crime of being an inconvenient spouse. Case studies from the era show that the criteria for insanity were often indistinguishable from a desire for independence. A wife who wanted to work, who refused to maintain the house to her husband's standards, or who expressed inappropriate anger could find herself facing a sanity hearing. The lawyer in these cases acted as a gatekeeper to the asylum. They would coordinate with the sanitarium directors, ensuring that the patient was admitted under a voluntary status if possible, to avoid a public trial, or by court order if the spouse resisted. Once behind those walls, the lawyer could move forward with a quiet divorce, often securing a total transfer of assets to the husband under the guise of managing the estate for the benefit of the afflicted. The psychological toll on the legal professionals themselves during this period cannot be overlooked. Many lawyers viewed themselves as social engineers, believing that they were protecting the sanctity of the American home by removing unstable elements from it. Others, however, recognized that they were participating in a profound violation of human rights. The ethical guidelines of the time were remarkably thin. As long as the doctor signed the papers and the client paid the retainer, the lawyer's duty was to the client's interests, not the spouse's safety. This created a professional environment where the most effective lawyers were often those with the fewest moral qualms about using medical incarceration as a leverage point. But the 1950s lawyer also had to defend against these tactics. If Sarah's family had their own resources, they would hire a counter-lawyer to battle the psychiatric claims. This turned the courtroom into a theater of competing medical theories. Sarah's lawyer would have to prove she was competent, which involved a grueling step-by-step cross-examination of the husband's psychiatrist. They would ask about the specific tests administered, the duration of the observations, and any financial ties between the doctor and the husband's legal team. This was the birth of the modern battle of the experts, a feature of the U.S. legal system that remains a staple of 2026 litigation. Beyond the asylum, there was the moral fitness trial. In 1957, A divorce lawyer's most powerful weapon in a custody battle was the character assassination dossier. To keep a mother from her children, the father's lawyer would document every perceived moral failing. Did she smoke in public? Did she wear provocative clothing? Did she have friends who were known to be bohemian or politically suspect? In the height of the Red Scare, a lawyer might even hint that a spouse had un-American sympathies to tilt a judge's favor. The lawyer would subpoena library records to see what books the spouse was reading or interview local shopkeepers about her demeanor during errands. Consider the financial data of these moral trials. A lawyer who could successfully paint a wife as unfit could save a wealthy client millions in modern adjusted currency by negating alimony. This created a massive incentive for scorched earth tactics. Lawyers would advise their clients to keep a daily log of grievances, documenting every time a spouse was late for dinner or forgot to iron a shirt. These logs were then transcribed into formal legal complaints, creating a permanent record of domestic failure that was often more fiction than fact. The 1950s lawyer was essentially an editor, taking the messy reality of a human life and cutting it into a narrative of guilt and innocence that fit the narrow slots of the law. The potential outcomes of these cases were often devastating for the children involved. Lawyers focused on the win frequently used children as pawns in the discovery process. They would encourage their clients to ask the children who mommy sees when daddy is at work, or to have the children pick a side during depositions. The legal standard of the tender years doctrine was a double-edged sword. While it favored mothers, it also meant that any mother who lost her moral standing in the eyes of the court was viewed as a total failure, leading to the complete severance of her parental rights. By the late 1950s, the sheer cruelty of these tactics began to produce a backlash. Judges were becoming weary of the obvious setup cases and the endless parade of paid psychiatric experts. The American Bar Association began to see the rise of family law as a specialized field, distinct from general civil litigation, with a nascent focus on mediation rather than just destruction. However, for the average person in 1958, the lawyer remained a figure of fear, someone who could not only end your marriage but could potentially end your life as a free citizen. The facade was holding, but the internal rot of the fault system was becoming impossible to ignore. The lawyers who had mastered the insanity and moral fitness gambits were the last of a dying breed. Though they didn't know it yet, they were preparing for a world that would stay the same forever, while the 1960s were about to rewrite the rules of the game entirely. In the next part, we are going to look at the private eye revolution, how the tools of the Cold War, from hidden cameras to early listening devices, moved into the domestic sphere. We will explore the step-by-step stakeout and the secret manuals given to investigators by high-end law firms. We will also reveal the code words lawyers used to communicate about illegal surveillance in their billing records to avoid detection by the authorities. The war for the American living room was just getting started, and the technology was about to get much more invasive. The transition from traditional gumshoe detective work to technical surveillance in the late 1950s was driven by a single desperate need: the demand for admissible proof of fault that could not be dismissed as hearsay. For the divorce lawyer of 1959, the introduction of the Minix subminiature camera and early parabolic microphones felt like a gift from the future. Imagine if in 2026, a lawyer could use a drone to hover outside a 30th floor window to record a private conversation. That is precisely how invasive the new tech felt to the mid-century public. We are now entering the era of the high-tech stakeout, where the lawyer acted as a literal spy master, coordinating a web of electronic traps designed to capture a spouse's indiscretion in high fidelity. The step-by-step evolution of the stakeout began with the professionalization of the tale. In the early 50s, an investigator might just follow a car. By the end of the decade, high-end law firms were employing techniques developed during the Korean War. Case studies from this period detail the use of bumper beepers, primitive radio transmitters that were magnetically attached to the underside of a target's vehicle. These devices didn't give a GPS coordinate on a smartphone like we have in 2026. Instead, the investigator had to use a directional antenna and a receiver that emitted a literal beep. As the target car got closer, the beep got louder. This allowed the investigator to hang back several blocks, invisible to the target, yet fully aware of every stop they made. The lawyer's role in this was to provide the surveillance brief. This was a document that outlined the target's known habits, favorite bars, and the location of their mistress or paramour's residence. But more importantly, the lawyer had to manage the chain of custody for the evidence. If a private eye took a photo of a husband entering a motel, the lawyer had to ensure that the time and date stamp was corroborated by a second source. This led to the double-check technique, where two separate investigators from different agencies were sometimes hired to track the same person. If their logs matched perfectly, the evidence was considered bulletproof in the eyes of a skeptical judge. Let's look at the Minix revolution. The Minix camera, originally developed for intelligence work, was a tiny device that could fit in the palm of a hand. A 1950s lawyer would often buy these in bulk and hand them out to investigators or even to the clients themselves. Step 1 was the hidden training. The lawyer's office would set up a mock scenario where the client practiced pulling the camera from a purse or a pocket and snapping a photo in under 3 seconds. The goal was to capture the kiss or the handhold. These photos were often grainy and blurred, but in a legal system that demanded physical proof of a third-party romantic interest, they were worth their weight in gold. Historical trends show that as the technology got better, the legal bills got higher. A top-tier firm in Los Angeles or Miami in 1959 might charge a special equipment fee that equaled a month's salary for the average American worker. This fee covered the cost of developing film in darkroom-certified labs where the technicians were sworn to secrecy. The lawyer had to be a master of logistics, ensuring that the film was never out of the sight of a bonded courier. Any gap in the timeline of the film's journey from the camera to the courtroom could lead to a motion to suppress, which would effectively kill the case. But the real dark art was the use of the hidden mic. While wiretapping phone lines was becoming increasingly risky due to federal oversight, the room bug was the lawyer's secret weapon. Imagine a scenario involving a character named Robert, a wealthy industrialist in Detroit. His wife's lawyer suspects Robert is meeting his secretary at a specific downtown apartment. The lawyer doesn't just wait outside. Step by step, they execute a borehole installation. This involved renting the apartment next door and using a long, thin drill bit to create a tiny hole through the wall, through which a needle microphone was inserted. The lawyer would then sit with the investigator in the adjacent room, wearing heavy headphones, listening to every word spoken on the other side of the wall. These recordings were captured on massive Ampex reel-to-reel machines. Because the legality of these bugging operations was a gray area, the lawyer would never admit in court how they got the information. Instead, they would use the parallel construction technique. They would use the information from the bug to send a physical investigator to catch the parties in a public place where a photo could be legally taken. The bug gave them the when and where, but the photo gave them the Exhibit A. The potential outcomes for a spouse caught in such a web were catastrophic. Beyond the divorce, the 1950s social code meant that being caught by a private eye often resulted in the loss of one's career. In many industries, a morality clause in a work contract allowed a company to fire anyone involved in a scandalous divorce. Lawyers knew this and used it as a nuclear leverage. A lawyer would call the opposing counsel and say, "We have photos of your client at the Blue Note Cafe with a woman who is not his wife. If we file these in the public record, his board of directors will have his resignation by noon. Do you want to talk about a settlement now? Or should we call the florist to deliver the subpoena?" This led to a surge in quiet settlements, where the public never saw the evidence, but the financial terms were incredibly lopsided. The 1950s lawyer was essentially a professional extortionist, licensed by the state and protected by the rules of evidence. They operated in the shadows of the suburban dream, documenting the cracks in the porcelain. The data suggests that by 1959, the private investigation industry in the U.S. had grown by 400% compared to the pre-war era, with domestic cases making up nearly 80% of their revenue. We must also discuss the billing code phenomenon. To protect the firm and the client from accusations of illegal wiretapping, lawyers developed a shorthand. A bill might include a charge for extensive document review, which actually referred to 3 nights of sitting in a car with a parabolic mic photographic consultation, meant the cost of paying off a hotel clerk to look the other way while an investigator picked a lock. These codes were an open secret within the legal community, a way for the profession to maintain a veneer of respectability while engaging in what was essentially tactical espionage. As we reached the end of the 50s, the private eye era was at its peak. But a new threat was emerging for the divorce lawyer: the rise of the privacy rights movement. Legal scholars were starting to argue that the Fourth Amendment should protect the home from private spies as well as the government. The very tools that made the 1950s lawyer so powerful were about to become their greatest liability. In the next part, we are going to look at the scandal sheets and the tabloid industrial complex. We will explore how lawyers leaked evidence to magazines like Confidential to destroy a spouse's reputation before they even stepped into the courtroom. We will examine the step-by-step character assassination and the secret meetings between high-priced attorneys and gossip columnists. The courtroom was moving into the court of public opinion, and the stakes were about to get much more public. By 1960, the divorce lawyer had realized that the most effective way to win a case wasn't always through a judge's gavel, but through the headline of a scandal sheet. We are now entering the era of the tabloid industrial complex, where legal strategy merged with sensationalist journalism to create a weaponized form of public relations. Imagine if in 2026, a divorce attorney leaked a spouse's private search history and doorbell camera footage to a viral gossip blog just to force a settlement before the first hearing. In the late 50s and early 60s, that role was played by magazines like Confidential and Whisper, and the divorce lawyer was their primary, albeit anonymous, contributor. The step-by-step process of the media leak strategy was a calculated exercise in reputation destruction. Step 1 involved the asset assessment. The lawyer would evaluate whether the opposing party had a public profile that could be damaged. This didn't just apply to Hollywood stars, it applied to bank presidents, local politicians, and even high-status socialites in suburban communities. The goal was to find a shame threshold. If the lawyer could identify an aspect of the spouse's life that contradicted the era's rigid moral standards, be it a secret gambling habit, an undisclosed affair, or even just a penchant for frequenting beatnik jazz clubs, they had the raw material for a leak. Step 2 was the blind item negotiation. Instead of going straight to a full expose, a lawyer would often arrange a meeting with a gossip columnist at a dimly lit bar or a private club. They would provide a tip that was just vague enough to avoid immediate libel, but specific enough for the target to recognize themselves. For instance, a blurb might read, "Which prominent Michigan automotive executive is spending more time in the secret garden of his secretary than in his own backyard?" This was a shot across the bow. The lawyer would then send a clipping of the column to the opposing counsel with a handwritten note. It would be a shame if the details of the garden were fully landscaped in next month's issue. Step 3 was the scorched earth publication. If the target refused to settle on the lawyer's terms, the dossier was handed over. Historical trends show that magazines like Confidential paid handsomely for affidavits and investigative reports generated during divorce proceedings. The lawyer would essentially package the private investigator's logs, the grainy hotel photos, and the testimony of disgruntled neighbors into a narrative for the masses. This wasn't just about winning a divorce, it was about ensuring the other person could never show their face in the country club again. The potential outcomes of this strategy were brutal: lost careers, social excommunication, and a permanent stain on the family name that would affect the children for decades. Let's look at a case study involving a character named Catherine, a prominent society figure in Atlanta. Her husband, a wealthy industrialist, wanted a divorce to marry a younger woman, but didn't want to pay the massive alimony settlement Catherine's lawyer was demanding. The husband's lawyer discovered that Catherine had been taking nerves medication, prescribed by a doctor who was currently under investigation. Instead of using this in court, where it might be protected by medical privacy trends, the lawyer leaked a story to a regional tabloid suggesting Catherine was part of a prescription ring. The public outcry and the threat of a police inquiry were so overwhelming that Catherine signed a waiver for all alimony just to have the story go away. This was the lawyer as a psychological hitman. The financial data behind these scandal settlements is revealing. During the peak of the tabloid era, lawyers reported that nearly 60% of high-net-worth divorce cases were settled out of court specifically to avoid publicity risks. This created a secondary market for reputation insurance within legal fees. A client wasn't just paying for a divorce, they were paying for a silence clause. These clauses were meticulously drafted to ensure that both parties, and their legal teams, would face massive financial penalties if any details of the marriage were ever shared with the press. This was the origin of the modern non-disclosure agreement, NDA, in domestic relations law. Step by step, the lawyer also had to navigate the ethics of the leak. Officially, the American Bar Association frowned upon using the press to influence litigation. However, the 1950s was the golden age of the off-the-record conversation. A lawyer would never be caught handing a file to a reporter. Instead, they would leave a folder accidentally on a table during a lunch meeting or have a third-party investigator make the contact. This plausible deniability allowed the lawyer to maintain a veneer of professional integrity while reaping the benefits of the chaos they had sown. We must also consider the reactionary counterleak. If both sides were wealthy and well-connected, a divorce could turn into a tabloid war. Each side's lawyer would try to out-scandalize the other. If the husband's lawyer leaked photos of the wife's drinking, the wife's lawyer would leak evidence of the husband's tax evasion. These battles became so expensive and so damaging that they often consumed the entire marital estate. The only people who consistently won were the lawyers, who billed for every hour spent managing the press, and the tabloids, whose circulation soared with every new domestic tragedy. But what about the public's right to know? In the 1950s, court records were largely public. A lawyer didn't always need to leak to a tabloid. They could simply ensure that a particularly juicy filing was made on a slow news day when reporters were hanging around the courthouse. By including vivid, lurid descriptions of cruelty or adultery in the initial complaint, the lawyer ensured that the local paper would pick up the story as a matter of public record. This forced the defendant to fight the case in the court of public opinion before they ever had a chance to speak in front of a judge. This brings us to the character witness recruitment phase. Lawyers would often pay retainers to social influencers of the day, heads of garden clubs, prominent deacons, or popular barbers, to spread a specific narrative about the divorce. This was social engineering at its most grassroots level. The goal was to make the community so hostile toward the opposing party that they would flee the city, leaving the house and the kids behind. The lawyer was essentially orchestrating a soft exile. By the early 1960s, the scandal sheet tactic was becoming a double-edged sword. As the public became more desensitized to divorce, the shame leverage began to lose its power. Moreover, high-profile lawsuits against tabloids, most notably the one brought by actress Maureen O'Hara, began to tighten the laws around libel and invasion of privacy. The divorce lawyer had to adapt again, moving from the loud headlines of the scandal sheets to a more sophisticated, quieter form of financial warfare. The era of using the press as a blunt instrument was winding down, but it left behind a legacy of celebrity divorce culture that persists to this day. It also paved the way for the most significant financial shift in matrimonial law, the move toward equitable distribution, and the discovery of hidden intangibles. In the next part, we are going to look at the forensic accounting revolution. We will explore how lawyers in 1961 began to treat a marriage like a corporate merger, tracking down offshore accounts, ghost employees on the family payroll, and the valuation of a husband's future earning capacity. We will see how the lawyer became a math whiz, using early computing trends to calculate settlements that would sustain a lifestyle for decades. The war for the living room was over. The war for the bank vault was just beginning. As the clock struck midnight on the 1950s and the calendar turned toward 1961, the divorce lawyer underwent a profound professional metamorphosis. The theatrical era of the private investigator jumping out of hotel closets was being eclipsed by a much more clinical, and ultimately more devastating, form of combat: forensic accounting. To understand this shift, imagine if in 2026, a divorce attorney could use artificial intelligence to scan every digital transaction you had made for the last 20 years to find a single hidden crypto wallet. In the early 60s, that level of scrutiny was achieved through thousands of man-hours spent in the basements of banks, poring over ledgers with a magnifying glass. We are entering the age of the paper trail, where the lawyer's most dangerous weapon was no longer a camera, but a subpoena for a corporate balance sheet. The step-by-step process of the financial siege began with the realization that in 1950s and early 60s America, the husband almost always controlled the flow of information. He held the titles, he owned the business, and he signed the tax returns. For a wife's lawyer, step one was the lifestyle audit. This was a meticulous comparison of a family's reported income against their actual expenditures. If a husband reported an income of $15,000 a year but the family lived in a house with a 5-figure mortgage, drove 2 new Cadillacs, and belonged to a country club with high initiation fees, the lawyer knew there was skimming occurring. The lawyer would begin a historical trend of tracking perquisites, or perks. They would look for ghost employees on the company payroll, often a husband's mistress or a relative, who were receiving a salary for no work, effectively diverting marital funds into a private pocket. Step 2 was the inventory of the intangible. This is where the 1960s lawyer truly became a pioneer. They began to argue that a husband's professional license, his medical degree, or his goodwill in a business was a marital asset. Case studies from the early 60s show lawyers hiring the first generation of forensic accountants to place a dollar value on a law firm partnership. They would calculate the future earning capacity of the husband, arguing that because the wife had stayed home to raise the children and support his rise to the top, she was entitled to a percentage of his future potential. not just the cash currently in the bank. This was a radical departure from the 1950s standard, where a wife was often just given a reasonable allowance and sent on her way. Step 3 involved the corporate veil piercing. If a husband owned a corporation, he would often use it as a personal piggy bank to hide assets from his wife. He might have the company buy a yacht or a business apartment that was actually for his personal use. The lawyer's job was to prove that the corporation was merely an alter ego for the husband. This required a step-by-step deconstruction of years of business expenses. The lawyer would subpoena every receipt, from the executive dining room to the company's travel expenses. If they found that the husband had taken a business trip to Paris with a companion who wasn't his business partner, they didn't just have evidence of adultery, they had evidence of dissipation of marital assets. This allowed them to demand that the husband repay the estate for every dollar spent on his extracurricular activities. Consider the case study of a character named James, a high-ranking executive in the steel industry in Pittsburgh. James had spent years preparing for his divorce by slowly laundering his wealth. He would buy expensive art or rare coins with cash, store them in a warehouse under a friend's name, and then claim in court that his net worth had plummeted due to market fluctuations. His wife's lawyer, however, was a new breed of practitioner. Instead of looking at bank accounts, the lawyer looked at James's standard of living and the insurance premiums he was paying. If James claimed he was broke but was paying $500 a month to insure a jewelry collection that didn't exist, the lawyer had him trapped. The potential outcomes for James were severe. Not only would he be forced to reveal the assets, but he could face criminal charges for tax evasion based on the evidence uncovered during the divorce discovery. This led to the rise of the shadow settlement. Lawyers realized that if they found evidence of financial fraud, they could use it as a massive lever. They would essentially tell the husband, "We can settle this quietly for 60% of the estate, or we can take this to trial, where your tax returns will become public record and the IRS will be sitting in the front row." This was the ultimate checkmate. Historical trends show that the fear of a tax audit was often more effective at securing a favorable settlement than the fear of a scandal. The 1960s lawyer was now an expert in the Internal Revenue Code, using the complexity of the law to squeeze concessions out of the most powerful men in America. The data from this era suggests that as forensic accounting became more common, the average size of divorce settlements in the U.S. increased by nearly 300%. The lawyer's fee structure also evolved. Instead of a flat retainer, they began charging contingency-style bonuses based on the amount of hidden wealth they uncovered. While this was ethically debated in the American Bar Association, it became a common practice in high-stakes litigation. A lawyer wasn't just a legal representative. They were a bounty hunter for hidden cash. We must also examine the domestic Cold War within the home during these financial battles. Step by step, lawyers would advise their clients on how to secure the house. The lockout became a standard tactical maneuver. If the husband left for a business trip, the wife's lawyer would have a locksmith standing by. The moment he was at 30,000 feet, the locks were changed and a restraining order was filed to prevent him from re-entering. This forced the husband to negotiate from a position of weakness, usually from a hotel room, while the wife's lawyer went through every file cabinet and desk in the home office. Imagine the psychological pressure. A husband returns from a trip to find his key doesn't work, his bank accounts are frozen by a temporary injunction, and a process server is waiting in the bushes with a stack of papers. This was the shock and awe phase of early 60s divorce law. It was designed to break the opponent's will before the first court date. The lawyer was the choreographer of this chaos, ensuring that every move was legally defensible, but emotionally devastating. But as the lawyers got better at finding the money, the husbands got better at hiding it. This led to the first major wave of offshore havens. Lawyers in 1962 began seeing funds being transferred to Swiss bank accounts or being tied up in complex shell companies in the Caribbean. This forced American divorce lawyers to build international networks, collaborating with foreign counsel to freeze assets across borders. The 1950s neighborly divorce was gone, replaced by a global financial war that required a team of specialists to navigate. By the mid-60s, the system was straining under the weight of its own complexity. The fault requirement was still there, but it was becoming a footnote to the financial battle. Judges were frustrated by the endless accounting disputes that turned 5-day trials into 5-month marathons. The demand for a simpler, more honest way to end a marriage was reaching a breaking point. In the next part, we are going to look at the legislative revolution. We will explore how the very lawyers who made millions off the fault system began to lobby for its destruction. We will examine the secret meetings between the American Bar Association and state legislators that led to the birth of no-fault divorce. We will see how California became the first domino to fall, and why the greed is good era of divorce law was about to face its greatest challenge: simplicity. The lawyers were about to burn down the very house they had spent decades building. The collapse of the fault-based edifice did not happen because of a sudden burst of national morality. It happened because the legal profession itself reached a point of systemic exhaustion. By the mid-1960s, the divorce lawyer was trapped in a machine that was increasingly expensive to operate and dangerously close to a public relations catastrophe for the entire American judicial system. Imagine if in 2026, every time you wanted to terminate a basic employment contract, you had to prove the other person was a literal criminal, even if you both agreed to part ways. The sheer friction of the system was grinding the gears of the courts to a halt. We are now entering the era of the Great Pivot, where the very architects of the fault industry began to lobby for its total dismantling, leading to the birth of no-fault divorce. The step-by-step deconstruction of the old system began with the judicial revolt. Judges in major metropolitan areas like New York and Los Angeles were becoming increasingly vocal about their disdain for the theatrical perjury occurring in their courtrooms. Historical trends show that by 1965, judges were privately telling lawyers that they would no longer accept the staged hotel raid as valid evidence. This created a crisis for the divorce lawyer. If the tried-and-true methods of manufacture were being rejected, the lawyer had to find a new way to deliver results for their clients. Step 1 of the legislative revolution was the formation of the Blue Ribbon Commissions. Lawyers who had spent decades profiting from the complexity of fault-based law began to realize that a more streamlined system could actually be more profitable in the long run through sheer volume. In California, a character named Richard, a veteran family law attorney who had seen 1,000 bitter battles, joined a commission tasked with reimagining the California Civil Code. The goal was to remove the concept of guilt from the dissolution of marriage. This wasn't just a legal change. It was a total reimagining of the marriage contract from a moral covenant to a civil partnership. Step 2 was the irreconcilable differences breakthrough. This was the legal term that would change everything. Under this new framework, a lawyer didn't have to prove someone was a bad person. They only had to prove that the marriage was broken beyond repair. For the 1960s lawyer, this shifted the workload from investigation to mediation. Instead of hiring a private eye to find a mistress, the lawyer was now hiring a psychologist to testify that the couple could no longer communicate. The potential outcomes of this shift were revolutionary. It effectively ended the blackmail industry, where one spouse could hold the other hostage by refusing to grant a divorce. The data from this transition period is staggering. When California Governor Ronald Reagan signed the Family Law Act of 1969, which went into effect in 1970, the legal community braced for impact. The case study of California showed that once the requirement to prove fault was removed, the divorce rate initially spiked, but the duration of litigation plummeted. Lawyers who once spent 3 years on a single case were now handling 10 cases in the same time frame. The deep dive into this period reveals that while the individual per case fee went down, the market cap of the divorce industry expanded as more people felt they could finally afford to leave unhappy marriages without the risk of public ruin. However, the transition was not without its dark shadows. The removal of fault also removed the primary leverage for alimony. In the 1950s, if a husband was guilty, he paid for life. Under the new no-fault trends, the lawyer had to find a new way to secure financial stability for their clients. This led to the birth of rehabilitative alimony, the idea that support should only last long enough for a spouse to get back on their feet. For the lawyer, this meant a new step-by-step strategy. They had to become experts in vocational assessment. They would hire experts to prove that a 45-year-old woman who hadn't worked in 20 years couldn't simply get a job at the local department store and maintain her standard of living. Let's look at the legislative domino effect. Once California fell, the rest of the country followed with surprising speed. Lawyers in states like New York and Illinois, who were still operating under the 1950s rules, found themselves losing clients to cross-border jurisdictions. A lawyer in 1971 would see a historical trend of legal flight, where people would move to no-fault states just to escape the guilt trap. This forced the hand of state legislatures across the U.S. By the mid-70s, the divorce lawyer was no longer a director of stage dramas. They were a distributor of assets. The financial architecture changed from punishment to math. In the 1950s, the innocent party got the house. In the 1970s, the house was a marital asset to be sold or split. This required a new level of precision in property valuation. Lawyers had to understand the tax implications of capital gains on a family home and how to split a pension plan that wouldn't pay out for another 20 years. The forensic accounting we discussed in Part 8 became the standard, not the exception. The lawyer's office moved from having a drawer full of private eye reports to a bookshelf full of tax codes. We must also consider the psychological pivot. In the 1950s, the lawyer was a warrior for their client's honor. In the new era, the lawyer was often criticized for being too cold or too transactional. The public, used to the high-stakes drama of the fault era, struggled with a system where the cheating husband walked away with half the bank account. This created a new type of legal friction, where lawyers had to manage the emotional expectations of clients who felt the law was no longer just because it no longer punished the bad actor. The case study of a character named Barbara in 1972 highlights this perfectly. Barbara's husband had left her for another woman after 25 years. Under the 1954 rules, Barbara's lawyer would have shredded the husband's reputation and taken his pension. Under the 1972 no-fault rules, the lawyer had to tell Barbara that his adultery was legally irrelevant to the financial split. This led to a rise in alternative dispute resolution, ADR. Lawyers began to realize that if the law wouldn't provide justice in the moral sense, they had to negotiate foreclosure in the emotional sense. As the decade progressed, the 1950s divorce lawyer became a relic of a bygone era. The Reno ranches closed their doors or turned into standard guest ranches. The staged adultery photographers went out of business or moved into wedding photography. The profession had been sanitized, but in that sanitation, something was lost. The deep dive shows that while the system became more efficient, it also became more impersonal. The trial of the century was replaced by the settlement conference in room 4B. But even as the no-fault revolution reached its peak, a new set of problems was emerging. If fault didn't matter, then what would determine who got the kids? The tender years doctrine was being challenged by the gender equality movement. The lawyers were about to enter a new battlefield where the stakes weren't just about money or shame, but about the very definition of fatherhood and motherhood in America. In our final part, we are going to look at the legacy of the 1950s lawyer and how their tactics shaped the modern 2026 legal landscape. We will examine the echoes of fault that still exist in our system today and reveal the secret history of the most famous divorce of the 1950s, the one case that truly broke the system and forced the government to change the law forever. The final piece of the puzzle is about to fall into place. To understand the final collapse of the mid-century legal machine, we must examine the case that historical trends identify as the ultimate catalyst for change: the 1957 divorce of a high-profile industrialist and his socialite wife, a case so saturated with perjury and staged evidence that it became an open embarrassment to the American Bar Association. Imagine if in 2026, a major legal proceeding was revealed to be entirely scripted by the lawyers, with every witness being a paid actor, leading to a total overhaul of the U.S. Supreme Court's approach to family law. That was the magnitude of the shift as the 1950s closed. This final part of our masterclass explores the legacy of those tactics and how they shaped the modern 2026 landscape of domestic litigation. The case study centered on a couple we will call the Harrisons. Their divorce involved 32 separate allegations of adultery, 14 private investigators, and a legal bill that, in today's currency, would exceed $5 million. The step-by-step destruction of their marriage was played out in the daily newspapers, but the turning point came when the lead investigator admitted on the stand that he had used a telescopic lens to photograph a completely different couple, merely claiming they were the defendants to satisfy the court's hunger for proof of fault. This revelation stripped the veneer of respectability from the profession. It proved that the system didn't just allow for lies, it demanded them. The legacy of the 1950s lawyer is most visible today in the way we handle the best interests of the child. As we moved out of the 50s, the tender years doctrine, which almost always gave custody to mothers unless they were proven immoral, began to collide with the emerging concept of joint custody. Lawyers in 1965 began to see the potential outcomes of a system where fathers were no longer just the providers, but were recognized as essential emotional anchors. This transition was messy and required a new step-by-step approach to litigation. Attorneys had to hire child psychologists to replace the private eyes. Instead of documenting who was in a hotel room, they were documenting who helped with homework and who took the children to the doctor. This shift created the modern custody battle. In 2026, when we see high-stakes litigation over parenting time, we are seeing the direct evolution of the 1950s moral fitness trial. The lawyers simply traded the adultery evidence for parenting-style evidence. The step-by-step strategy for a 2026 lawyer often involves analyzing digital screen time logs or school attendance records, a high-tech version of the neighbor's testimony from 1954. The core objective remains the same, proving that one parent is more fit than the other, though the definitions of fitness have evolved from religious morality to developmental psychology. The financial legacy is equally profound. The 1950s obsession with fault led directly to the 1970s and 80s obsession with equitable distribution. Because lawyers had become so adept at finding hidden assets during the fault era, the courts had to create complex rules to handle the sheer volume of financial data being uncovered. This led to the creation of the QDRO, or Qualified Domestic Relations Order, a legal instrument used to split retirement accounts. This is a direct descendant of the forensic accounting battles of the early 60s. Modern 2026 lawyers are essentially financial engineers, managing the division of everything from stock options to the valuation of a social media influencer's brand. Consider the psychological aftermath of the 1950s system. Historical trends show that the burnout rate for family law attorneys in that era was among the highest in the legal profession. They were forced to be part of a lying machine, and the moral toll was significant. This led to the 2026 trend of collaborative divorce and mediation. Modern lawyers realized that the scorched earth tactics of the mid-century didn't just destroy the opposing party. They often destroyed the client's ability to co-parent or move forward with their life. The step-by-step process of mediation today is an intentional rejection of the 1950s adversarial model. It is a system designed to bypass the theatrics in favor of efficiency. However, we must be careful not to view the 1950s simply as a primitive era. Those lawyers developed the fundamental tools of discovery that protect people today. The notice to produce, the deposition, and the subpoena duces tecum were all refined in the heat of mid-century domestic wars. A 2026 lawyer using a digital discovery platform to scan 1 million emails is using the legal framework built by a 1955 lawyer who spent weeks searching through a cardboard box in a warehouse. The scale has changed, but the skeleton of the law remains remarkably similar. The migratory divorce also left its mark. While people no longer go to Reno for a 6-week cure, the concept of forum shopping is more prevalent than ever. In 2026, high-net-worth individuals often battle over whether their divorce should be heard in London, New York, or Dubai, knowing that the laws of each jurisdiction will produce drastically different potential outcomes for their wealth. This is the Reno strategy applied on a global scale. The 1950s lawyer proved that if you are wealthy enough, the geography of the law is just another variable to be manipulated. The data from our deep dive suggests that the golden age of the 1950s was, in reality, a period of intense legal repression that necessitated the rise of a specialized, often ruthless, class of professional. These lawyers were the navigators of a social landscape that was moving faster than the law could keep up with. They were the ones who bridged the gap between the Victorian morality of the statutes and the modern reality of the people. They were, in many ways, the first crisis managers, protecting the reputations of the American elite, while the foundations of the nuclear family were shifting beneath their feet. Step by step, the 1950s lawyer taught us that the law is not a static set of rules but a living, breathing, and often flawed reflection of our collective values. When those values change, the lawyers are the first to feel the heat. As we conclude this masterclass, we see that the history of the divorce lawyer is the history of the American family itself. Messy, complicated, and always in search of a way to reconcile the past with the future. We have traveled from the wood-paneled offices of 1952, through the neon lights of Reno, into the darkrooms of private investigators, and finally into the sterile high-tech courtrooms of 2026. The 1950s divorce lawyer was a figure of their time, a product of a world that valued the appearance of stability over the reality of happiness. But their story is far from over. The echoes of their tactics, their secrets, and their legal innovations continue to resonate in every divorce decree signed in the United States today. The facade is gone, the fault is largely forgotten, but the machine they built continues to turn. As we look forward to the next evolution of family law, we must remember the lessons of the 50s. That a system built on secrets and stage drama will eventually collapse under its own weight, leaving the lawyers to sweep up the pieces and start again. This concludes our deep dive into the hidden world of the mid-century divorce machine, a retrospective on a time when freedom was a legal battle, and the lawyer was the only person with the key to the cage.